So the title obviously draws on two of Guido's articles for reason. Risk distribution in the law of torts. I didn't say "and" for a reason, because my claim is going to be that the best description of tort law, the best way to understand tort law, is in terms of the way that it distributes risk in a particular kind of way. So this is an analysis that is about how tort law actually exists and how one ought to understand tort law. Carrying Calabresi further refers to the kind of economic analysis that I use in engaging in this enterprise. This morning, the speakers discussed the ways in which what is distinctive about Guido's approach is that it's not all about efficiency or maximizing wealth. Of course, that matters, but there's more to it. Distribution matters, justice matters, and so on. But how is it that an economist accounts for that? Steve's paper this morning, and a portion that he didn't describe, says, it is sort of a puzzle. You're an economist, you know about allocative efficiency, but this other stuff about distribution is outside of our training, it's outside of our comparative advantage. So what do we really have to say about that? How does one go about doing this? All right, now I didn't sit down and write this paper to answer that particular question. What I did in the approach that I'm describing in this paper here, I've developed over the last 10 years. And I developed it because I'm a lawyer. I have training in economics, I have a PhD in economics, and I have a JD law degree as well. And so I am after Calabresi in the literal sense that law and economics by the 1980s was a conventional form of analysis, and that if you wanted to get a position on a law faculty like I did, then getting a PhD and a JD was a very good idea, excellent training. Now, Laura pointed out in her paper yesterday, what happens when you have these two professions and two different sets of norms? What happens to you? Do you sort of evolve into a new hybrid in which you have your own norms? I guess I'm not that independent, and I think this is true of most joint degree people I know, is that you tend to find that the norms of one or the other disciplines just sort of fits you better. And what I found is that I'm a lawyer. I mean, I loved economics is what I first studied, and I think it's incredibly valuable, but I found that really I'm a tort lawyer. I love tort problems, and for me that means that if there is a fact pattern before me, I need to have a line of analysis that enables me to give a concrete answer to that particular question. I need to resolve the case before me. I can't end up with vague generalities, or I can't sort of give a recommendation and then leave it to a decision maker to resolve the decision. I want to tell the decision maker what the answer is and persuade the decision maker that this is the best answer. And so what I'm going to do here is my thanks to Joseph for putting this on. This is the way in which law and economics from my own background is incredibly helpful for being a lawyer. What I found is that having been trained in the conventional economic analysis of tort law, and then having taught tort law for a number of years and practiced tort law, that I could get about 80%, if you were to put a number on it. About 80% of the time, I could use that line of analysis to answer the questions in the way that I wanted to as a litigator or a torts professor teaching my students. But 20% of the time, I was really just trying by brute force of argument to push this through, but I wasn't really persuading myself. The other thing that I found is that the language of economics is not the language that you use in a legal brief. It's not the way that you argue before a judge, and so on. And so you have to translate. So there's this kind of mysterious process of translation that occurs that means that there's something, again, missing within the conventional economic analysis of tort law. And so a reason why lawyers tend to be resistant to economic analysis is they say, well, that's not how I argue cases. I haven't been relying on this before, so why in the world would I need to understand this whole body of law? And that's really the kind of history that Guido described, as he would lay out his analysis initially, and lawyers would just say, that's interesting, but that's not the laws, because that's not what I've been doing, and I've been pretty successful at what I've been doing. And so it is quite true that there is something missing in just cost minimization and so on that a lawyer finds puzzling. Now, my own experience, having been trained in this, is that the economic analysis allows me to sharpen problems, it gives me a line of analysis, but I still needed something more. And so for the last 10, 15 years, I've been trying to figure out what's a way of understanding tort law that allows me to go that extra distance. And so this theory that I'm laying out in part 2 of this paper is exactly that theory. So there's a whole set, I've got 3 books, multiple articles, in which they're really just kind of tort. I'll take a tort doctrine and I'll test this line of analysis against that doctrine to see whether it adequately explains this doctrine and whether it provides a more compelling answer than the competing explanations. And so what I'm doing now, and when I would go to tort conferences and do these kinds of analyses, people would say, well, you're doing law and economics, but it's not law and economics of the sort I know. What are you doing? And so this is an opportunity for me to be more clear, at least as an economist, what it is precisely that I'm doing. So one way of framing the problem is just to think about the European Union Products Liability Directive. It says, that we're going to define safety, we're going to define a defect in a product in terms of what an ordinary person would reasonably expect about product safety. All right, that's pretty ambiguous, that's pretty vague. So an English case involving the distribution of contaminated blood. What does an ordinary person reasonably expect about a blood transfusion? Of course, you would, on one level, expect the transfusion to not be contaminated by the hepatitis virus. And so in that respect, your expectations are frustrated. That makes the blood defective and subject to strict liability. But then you recognize, well, wait a second, we don't expect perfection. We know that defects happen out there in the world, that manufacturers don't have perfect quality control and so on. So why would we expect perfection in this context? You start to play with the concept of expectations untethered from anything else, and you recognize the cost factors in somehow, but you're not sure exactly how cost factors in. And so there's an ambiguity, in other words, that you need to interpret, and then you need to provide an interpretation to the court that's going to resolve this particular dispute. All right, now the interpretation that I've developed, if I'm going to justify it in economic terms, which is of course appropriate for this conference, we'll start off, and the justification is going to take the form of the kind of economic analysis that I think Guido has been talking about. I'm not saying this line of analysis is one he would buy into, but it's the type of analysis that I think is envisioned by Guido's discussion of distributive matters. All right, so if we think about the Pareto Principle, obviously within welfare economics, the Pareto Principle is where distributive concerns get factored into our thinking about problems in economic terms. Now, when you have, perfect competition or fully consensual exchange or something like that, notice how you really don't need to worry about big questions of philosophy or whatever, because the fact of a consensual exchange does 2 things simultaneously. We know it promotes the welfare of both parties, and therefore the welfare of society more generally. But we also know that it promotes freedom or autonomy, that the parties have voluntarily entered into this transaction. And so for both of them, it furthers their own interests. And so whether we think about social justice in terms of welfare or freedom doesn't matter under conditions in which we have consensual exchange. The difficulty arises, of course, what happens when we don't have fully consensual exchanges, and that is the domain of tort law. What happens when we have risky interactions in which there is no agreement between the 2 parties and therefore no possibility of compensation before the fact? What do we do then? Now, this is where you get the divide between welfarism or utilitarianism and other versions of justice. Under non-ideal conditions, instead of using the Pareto Principle, if you're a utilitarian or somebody who just believes about maximizing social welfare, you use the Calder-Hicks criterion. All you care about really is, can I quantify the benefits? Can I quantify the costs? And as long as I'm confident about my 2 quantities there, as long as the benefits exceed the costs, this is a change that's going to increase wealth or welfare, and therefore it ought to be done. That's the basis of cost-benefit analysis. Not the only way to use cost-benefit analysis, but that is a foundation for cost-benefit analysis. Now, on this view, of course, consent is irrelevant and compensation is irrelevant. All that we care about is our ability to measure accurately whether the benefits exceed the costs. And that's why this is just purely about promoting social wealth or welfare and nothing else. Now, if you are instead, what you liked about the Pareto Principle is the way in which it promotes freedom, then you're going to have a very different take on what we do under non-ideal conditions. We no longer have consent. So in a situation in which we're lacking consent, the fact that it might satisfy this social cost-benefit calculus doesn't matter. So as Enrico said this morning, it's my body. I have a property right in my body. You can't just take it from me because cost-benefit analysis says you can. You've taken something from me and you owe me compensation as a result. So on that conception, compensation matters because you've taken something. You've violated a property right. All right, now another understanding of freedom is not the libertarian understanding. It's the understanding that I'm going to argue for here, not because as a political philosopher I think this is the best way to understand the world, but because as a tort lawyer I think this is the best way to describe tort law. And that's based on individual autonomy or self-determination. The reason why we care about consensual exchanges is that it allows me to figure out how I want to pursue a life of my own choosing. That kind of grand talk that's fairly common within liberal democracies. And so the idea is just that we decide how to live our life, and we go about doing so. Compensation matters on this view, not because you've taken something that's mine. Of course, it's my body, but that's not what's important here. What's important here is you've taken a resource from me that disables me from furthering my own projects in the world. And as a result, you need to give me other resources that are going to enable me to continue my projects moving forward. It's not about ownership, it's about opportunities for self-development or whatever. That's what's going on the autonomy-based rationale. Now, if that is in fact what is appealing about the Pareto Principle, then what we can do under non-ideal conditions is we can ask ourselves first, given that there's no consent between the parties, let's make sure that the interaction is one that doesn't disrespect the autonomy of the adversely affected party. So, for example, if you're walking around the streets of New York City and the taxi cab drivers seem like they're just getting a great deal of fun out of honking and scaring you, they may be actually getting pleasure out of doing that, but they're disrespecting my autonomy. And so as a result, that's a benefit to speeding that doesn't count on this story. So you're going to, first of all, as an objective matter, ask yourself whether the interaction somehow disvalues the autonomy of one or the other party. And if so, those are going to be interactions that are not going to be governed by this kind of inquiry. You're going to instead prohibit that kind of behavior. So, but typically risk is an unwanted byproduct. We're driving on the highway or whatever. We don't want to get in accidents, but it is going to inevitably occur. Risk is an unwanted but inherent aspect of a lot of the activities in which we engage. So there's no disvaluing of other drivers' autonomy or anything like that. The problem then is one of figuring out how do we structure the risky interaction to ensure that it somehow embodies this ideal of autonomy or whatever that we're concerned about within the tort system. Compensation is a very obvious way for dealing with this problem. What does compensation do? The party that's benefiting from the activity has an obligation to take care of the party who's been harmed by it. There's deeper explanations than this, but I don't need to get into them for present purposes. Just the basic idea is that compensation serves an important role in enabling individuals to exercise their autonomy. That's a way that we can regulate risky interactions. Now notice then that what follows from this. So what we're going to do is we're going to structure the interaction between an injurer and victim to ensure that the victim is compensated by the injurer. This is just a liability rule, nothing other than a liability rule as Calabresi has developed it. So my claim is that at bottom, we can understand tort law by reference to a liability rule understood in compensatory terms. But it's not going to be, how much time do I have left? I assume that, oh, okay, good, plenty of time. Okay, so that we're going to have a liability rule justified in compensatory terms. It's not going to be, again, an issue of ownership or anything else. It's an issue of compensation. All right, now when I translate this into tort doctrine, what is the form that this entitlement takes? What is the way that a tort lawyer would describe the kind of entitlement that I've just justified by way of the Pareto Principle under non-ideal conditions? We don't do it in the economic terms of the hand formula, which is one reason why the hand formula rings hollow when you talk about it to lawyers. So the hand formula, for those of you who don't know it, just says when we're thinking about structuring this risky interaction, we're going to compare the cost of the safety precaution that would be borne by the duty holder, and we're going to compare that to the risk that would otherwise be created that would threaten injury to the right holder. So the cost is represented by the burden of the precaution B, and then the safety, the risk posed to the other party is just the amount of injury L discounted by the probability of its occurrence, or the expected value of loss if you're an economist. And then we're just going to decide whether the cost is greater than the benefit, and we'll regulate the behavior in those terms. All right, now the rights-based people find this to be a very unsatisfactory description of what negligence law requires because, first of all, it gives no special recognition of the fact that one party is facing a threat of injury and the other party is the one creating the risk of injury. And so one of the reasons, if not the reason, why the Kosian move to just say that all interactions are reciprocal, and the reason why this would have been controversial had you put it in the footnote, is that if you allied the distinction between what we all think of as the injurer and the victim, then what you've done is you have eliminated what rights-based theorists would call the difference between my interest in physical security and your interest in liberty. And for a rights-based theorist, liberty and security are not the same thing. How are we going to compare them? How are we going to think about security versus liberty? Okay, now if our norm is one of autonomy, what we're going to ask ourselves is, of course you need liberty to exercise autonomy. Isn't that what it's all about? The rights-based theorists will tell you that that's certainly true, but prior to the exercise of liberty, we have to be secure in our bodies. We have to be confident that we're not about to die before we can make plans about what kind of degree we want to get or so on. We can't make future plans until we have adequate security, knowing that we'll have a future to live. And so from an autonomy perspective, both liberty and security matter, but security is prior to liberty. And so we're going to think about each of these interests by reference to a norm of autonomy. What's the importance of each in terms of the exercise of autonomy? But we're going to prioritize the interest in security. So in other words, due to that priority, we all have an individual right to physical security that can't necessarily be overridden by your exercise of liberty. You need to have the right kind of reasons in order to do so. And those reasons, I claim, are going to be satisfied if in interacting with me, you don't disrespect my autonomy and you compensate me for any harms that happen to me. If you do that, you then have protected my autonomy, and I let you act in the world. I let you drive your automobile around, even though you might end up going off the road and killing me as a pedestrian. So it lets you exercise your autonomy in a way that protects my security, but it prioritizes my security interest in the way that rights-based theorists do. Now, this is, again, just a compensatory liability rule of the type that Guido has long championed. And so I'm claiming you start with an entitlement defined in these terms, and from that entitlement, you can reason your way to the form that tort rules, at least in the U.S., take with respect to the occurrence of physical harm. Now, that would be puzzling at first glance because, of course, the default rule for torts in both the U.S. and around the world isn't one of strict liability, which seems like that's the rule I've just described. It's instead one of negligence. So how could this compensatory liability rule that I just talked about be one that underlies a default rule of negligence liability as opposed to just a general rule of strict liability? And this is where now the economist takes over, because now that I have the entitlement defined, then I can start to analyze what the consequences, the distributive consequences of this entitlement are for both the right holder and the duty holder. So the question is, as a right holder, I have a right to compensation. How do I want to exercise that right? What is best for me as the right holder in compensatory terms? Return to the products liability example. All right, now it's just up the middle economics that we know the right holder is the consumer, to think that somehow the consumer is getting compensation for free from the manufacturer duty holder is just illusory. You're going to pay for it by way of increased product prices. We can pile all the liability we want on the manufacturer, but it just gets internalized to the consumer due to the pre-existing contractual relationship. So in a situation like that, consumers have a right to compensation. How do they want to exercise that right? They want the manufacturer to make whatever investments in safety cost less, a cost borne by the consumer that would be less than the reduction in injury costs, another cost that's borne by consumers. You end up with a cost-benefit standard of care, a cost-benefit amount of safety, not because you're promoting social wealth, but because this is what's best for consumers. When the judge says it's not about efficiency, it's about fairness and justice to consumers, this is how you explain why cost-benefit analysis is appropriate. We don't use strict liability in this context, moreover, because if you ask the consumer, look, once you make the cost-benefit amount of care, there of course are going to be residual risks that are created by the product. What happens if you're injured by one of those residual risks? What do you, the consumer, want? Well, at this point, it's not about safety. It's just about compensation. All right, but it's not compensation that, again, comes for free because you, the consumer, are paying for this in terms of higher prices. So from the consumer's perspective, I can pay higher product prices, or I can get my insurance elsewhere. I can get first-party insurance, maybe through the government, depending on what country I live in. But the tort system is not the only source of compensation. And if I am paying for that compensation, I would prefer lower-cost insurance, which means I would prefer it outside of the tort system. So if we just care about consumers and nothing else, we end up with a cost-benefit negligence standard. We start off with an entitlement to compensation for autonomy reasons, not for reasons of social wealth, and we end up in contractual relationships like products liability with the same thing that you get with the ordinary economic analysis of law. But now you're justifying it with rights-based language, the kind of language that courts use when analyzing torts problems. And so you get that translation problem that I had been talking about earlier. All right, now what happens when we move outside of contractual relationships? The most important setting there is just think about what happens when we have an automobile accident, the most common form of tort liability. One driver is imposing a risk on the other driver. All right, now these are going to be cases of reciprocity. Reciprocity not defined in terms of causation as per Coase, reciprocity defined in terms of mutual benefit. What you recognize, if you are doing the same thing to me as I am doing to you, is that there's really no relevant difference between us. I can impose a compensatory obligation on you, but of course I'm going to face a compensatory obligation as well because I'm imposing a risk on you. So whatever happens to you also happens to me. In effect, analytically, there's no difference between the two of us in analyzing the implications of compensation here. We're identical in all relevant respects, so we can analyze the problem as if there is a single actor. All right, now again, if you're thinking about it in those terms, you recognize that the compensation costs are already internalized to the right holder, because the right holder, to the extent that he or she gets compensation, is going to pay for it as a reciprocally situated duty holder. So once again, it all gets internalized to the right holder, and so this entitlement to compensation gets transformed into a cost-benefit negligence rule. So you don't end up, then, with a world in which a compensatory entitlement leads to a general rule of strict liability, because tort rules can actually distribute risk in a cost-minimizing manner that would fully satisfy the demands of a compensatory right holder. So it is a form of compensation, but it's compensation that takes the form of risk distribution in order to make the world a safer place. That's how you satisfy the demands of a right holder in these cases. All right, now in thinking about reciprocity, just as a footnote, the way that this is done is not in the subjective terms of what are you right now actually doing to me. It's done as an objective matter. And so what tort law does, and there are normative arguments in favor of this, and this in fact is how the tort system does it in the U.S., we ask this as an objective matter. So automobile driving is common in the United States as it is everywhere else. So even though that's a risk that's above the ordinary level of risk that we all impose on each other, because the ordinary person drives any automobile accident, even if it involves a pedestrian or a bike rider or whatever, will be deemed to be a reciprocal risk within the U.S. under the objective standard. So it actually, when you frame it that way, reciprocity covers a large swath of risky behavior. Contractual relationships like products liability covers a wide swath of behavior. So that, in fact, is the 80% or so of tort law that you can explain with cost-benefit reasoning. But it drops out of rights-based reasoning, not about maximizing social wealth or welfare. So you can use the language that lawyers use, but you are structuring your argument in the way that economists do. So there's really no tension, ultimately, between the two types of justification in those classes of cases. What we have left is the remaining 20% that I had alluded to before, the cases I couldn't explain with deterrence-based economic reasoning. Those are the cases. These are going to be non-reciprocal risks, objectively defined, non-reciprocal risks that occur outside of contractual relationships. As I've argued elsewhere, that type of risk actually fully explains the pockets of strict liability within negligence. Negligence is objectively defined, so we can say somebody who has below average skills is negligent, but they're not blameworthy because they failed to act with ordinary skill. By having below average skill, they created an above average or non-reciprocal risk defined objectively and therefore can be subject to no fault or strict liability. So we have pockets of strict liability within the negligence standard. The rule of strict liability for abnormally dangerous activities, which comes out of the English case Rylands versus Fletcher, is defined in those terms. As long as the activity is not common in the community and it creates an abnormal danger, it's subject to strict liability. So this reasoning fully explains rules of strict liability that are in place for purely compensatory reasons. This is the way in which the right holder receives compensation under the rule of strict liability. Not to make the world a safer place, we're doing that under the negligence standard. But instead, that's the way in which the compensatory entitlement ends up being satisfied. So you get the remaining 20% of the cases, on my view, because those are cases in which tort law functions as compensation. What's the overall picture of tort law? It's mostly about deterrence, and sometimes it's about compensation. What's the standard story that a tort lawyer in the mid-20th century would tell you about what tort law does? They'd say it's about compensation and deterrence. It's about both functions, but they wouldn't be able to give you a very rigorous explanation as to how those two functions fit together. This is a story that, in fact, is able to explain how compensation and deterrence figure into tort liability. All right, now what's going on here to bring it back to Guido? If we understand the tort system in compensatory terms, then what you can understand tort liability is doing, if tort liability is satisfying the demands of the compensatory right holder, then what tort liability is doing is within Guido's language, the tort system actually pushes the Pareto frontier outwards. Under non-ideal conditions in which we don't have consensual exchanges possible, what tort law, you can understand tort law is doing, as it is structuring the interaction in a way that adequately compensates the losers of that interaction. And by doing that, the tort system continually pushes the Pareto frontier outwards. All right, now it's not always going to be allocatively efficient. As I described, there are going to be cases in which we're compensating because compensation is what's required by the right in question. It's allocatively inefficient, but that's what justice requires in these circumstances. Most of the time, it's going to be efficient. But most importantly, what we're doing conceptually is by structuring these interactions to ensure that compensation is afforded to the right holder, we're continually pushing the Pareto frontier outwards. And in that particular sense, illustrating that type of distributive economic analysis that Guido has relied on. Now, one last point, the way that Guido has been pushing the public-private distinction is also fully consistent with what I'm talking about here. So this is not an argument that says we have to have the tort system because justice requires that we have this linkage between the individual right holder and the individual duty holder. This is about the way that we protect physical security with deterrence and compensation. And we can achieve deterrence through regulation. We can achieve compensation through social insurance. So there's nothing that I've said that somehow implies that a system like New Zealand, or Europe for that matter, which has more regulation, more social insurance, and less tort liability than the U.S., none of this says that Europe or New Zealand is less just than the United States. There are different ways of protecting the interest in physical security through deterrence and compensation. And when you think about the problem in those terms, you could see that tort law is a private, decentralized mechanism for achieving this particular outcome. But there are collective mechanisms that might do a better job of doing this. And so we can understand tort law in private terms here as a decentralized way of pushing the Pareto frontier outwards. Not to say it's the only way of doing it. There can be collective mechanisms that may be better at doing this. And so this isn't an argument that says one or the other. It's just an argument that says, here's a way to understand tort law, has a lot of economics in it, certainly cares about distribution in the way that Calabresi has said that we as economists ought to, but more importantly, if you're a tort lawyer and you've got to make arguments to a judge and you want to tell the judge why is it that the ordinary person would reasonably expect that blood not to be contaminated in a way that results in a rule of strict liability, this is the kind of analysis that enables you to make that kind of argument. It works as a tort lawyer. I think it also works as a type of distributive economic analysis of the kind that Guido has championed, but there, I'm sure, are others. So it's just an example of where the kind of reasoning that Guido has given us with over his over a multitude of fabulous articles, where it might lead somebody like me. So thank you for having done that.
So many things in this talk that it's hard to know where to begin. I want to just focus on a couple of them. One is, at the beginning, a distinction is made by what Bruce Ackerman called scientific policy-making language and the language of law. Scientific policy-making in this context is the language of economics, but it can be anything else. And we don't, as lawyers, and I don't, as a judge, particularly appreciate somebody coming in and talking scientific policy language. I prefer the language of law for a variety of reasons. One of them is that any scientific policy is not going to be complete. Again, it will leave out what Mill called the unanalyzed experience of the human race. And so long as the language of law allows me to come out with results that are not too undesirable from the standpoint of scientific policy making, I prefer a language which is more general, a language of causation, and this, I wrote about in my article in honor of Harry Calvin, of how much of what we call causation can be termed in scientific policy making, but we use it because it allows us to introduce any number of other things. So we get somebody like Henderson strangely saying the ordinary person expectation test is meaningless, because you can describe it as being much too vague, but to the extent that that actually represents who is in a better position to decide, the producer or the user, that's a damn important test, every bit as important, maybe more important than his risk-utility ex post test. Okay, that's one thing. One could talk about that for a long time. Then the other thing that does trouble me a bit is that there is the suggestion that compensation comes first, and because of that, we structure things which happen also to bring about deterrence, that there is a priority in the decision of who is a victim and who is an injurer. That sounds almost like Richie Epstein, who says we talk about injurers and we talk about victims, and so we know who ought to compensate whom. My problem is that I believe that it isn't one that comes first and the other that comes after. They are both there. We call our injurer and victim in ordinary speech because we've already decided who compensates. I mean, we're also deciding who compensates whom. If it were the case that everybody who injured, everybody who did the physical harm on the other had to pay, and some nut named Geistfeld insisted on running into my car and I had to pay him, it wouldn't be long before we would say that I was the victim and he was the injurer, because that's the way we would describe that. And the same is true of compensation and deterrence. They are both things that we want, and each influences how we deal with the other. For me, the great classic example comes from the forms of action. The form of action in trespass was interested in compensation. It said, if you injure somebody directly, it doesn't matter if you're at fault, it doesn't matter if you're not at fault, it doesn't matter anything, you have to compensate. Straight Aristotelian compensatory justice. Why directly? Because we can't be responsible for everything in the world. And anyway, Aristotle himself didn't know how far compensatory justice or what it was. He just said it was there. At the same time, you had the cause of action on the case, which put liability in any number of situations where we didn't want to deter criminally. We didn't want to hang the innkeeper if somebody stole the goods. We didn't want to hang the husband if the wife did something negligent. We didn't want to hang the master if a servant did something. We didn't want to hang somebody if they were negligent. And we then got into the habit, I think, because if you look at some ancient laws, they didn't compensate, of having compensation in those cases. I don't believe there because we thought that there was a right that had been violated, but rather because this was an efficient way of bringing about this deterrence. By paying people off in a disorganized society, that worked. Well, what happened then? What happened then was that people got compensated for negligent wrongs, even if they were indirect in all the actions on case. Case did not deal with intentional wrongs. Why? Because you didn't need the system to compensate, to deter in that situation. You hanged the man, the person who was intentionally wrong. Finally, you get a case like Scott v. Shepard, where somebody intentionally injures somebody indirectly, and the person says, my goodness, if somebody had injured me negligently, indirectly, I'd have a right to compensation. I surely have a right to compensation here. And of course, that's the case. Now, that's a situation where I think the deterrence led to a right to compensation, which led to a change in law. I could give you as many examples of what you give in reverse. I think it takes two to tango, again, in a different context, that they both influence each other. And if you view it that way, you then also come to the fact that there are some things we want to do that we don't want to say too clearly. So we do want to compensate. We also want to price lives, but we don't want to say we price lives. And so we choose a system of compensation, because we want to compensate, that has the effect of pricing lives by saying it is too expensive for you to do this and not expensive to do that. And we achieve both of the things we want to do, but by saying we want to compensate and using that language, we hide the fact that we also are not going to save lives when it's too expensive to do so. So, in the end, I think one reason why we use law language is because there are some things that scientific policy-making language makes too clear. But the other reason is because we are constantly moving between these different goals, and each achieves the other. And that's what makes torts such a wonderful subject to teach, and what makes it such fun to be a torts law and economics scholar who is a judge, because as a judge, you of course always use the good law language, even Posner. uses for good law language, and always wondering about what is going on underneath and how one is influencing the other, which I think is really what you... But the one thing I would just be careful about making it sound too Epsteinian as being only running in one direction, because it runs both ways.
Yeah, no, so... So no, so that's, so the Epsteinian position is the one that Enrico articulated this morning. And the reason why, I think that position, whether it's defensible or not, is not really germane to my purposes, because what that particular conception leads to is a general rule of strict liability. Because you have taken something of mine and you owe me compensation for it, and which is Epstein's view, of course, is we ought to have strict liability all over the place, and of course we don't. So it might be, if a libertarian were the philosopher king, that might be the tort system that we now have, but that's not the tort system that we actually have. And so my task was just much more of, what is it, how can I formulate the entitlement in a way that explains the tort rules that we have? And so it is distinctly not of the type that Richard Epstein is talking about.
But you see, I think that even Richard, if he actually were the philosopher king and had established it, would then suddenly find that his language-based, you have taken something from me, would prove wrong, because the language would change, and he himself would say, oh, now we would move away from we would have strict liability in the reverse situation, because it would be absurd to say, if Geistfeld intends to run into my car, that I am injuring Geistfeld.
Yes. So that's undoubted, so I don't... And
but
in fact,
we'll leave
Richard
that
has
for Richard.
had his views evolve over time. But secondly, in terms of the early common law, so you, of course, know Latin so much better than I. So that phrase, that common law phrase, sicure, right? Yeah. Use your own so as not to injure another is the way that it loosely translates. So this is a common law maxim that Holmes, at great length in the common law, tries to show isn't really explain what's going on. All right, but that is a common law maxim that's been out there, and it's invoked in cases of strict liability to this day. You will see that maxim tossed out, and it gets rejected on the ground that, well, if that were really the underlying norm, why wouldn't we have this general rule of strict liability? And that's the norm I'm working with. And when we say who's the injurer and who's the victim, you're right, we have a preconceived notion of what those categories are. But what is it? I'm the one who suffered bodily injury. You're the one who was driving the car. That's why we call you the injurer and me the victim.
Is it that way?
That's
or is it
well,
because...
that's my claim. It's a way of understanding it, and I can't say that it's the way, but I can say it's plausible.
Let me just say something else on that. One way of looking at Pigou is that so much of what was done under microeconomics before Coase was right because they didn't have the theory right that it was actually reciprocal, but because they didn't have the theory right, empirically they decided quite well of who injured whom. Conversely, under Say's law, they had the theory right, but weren't looking at any of the transaction costs. So until Keynes came in and says, but in the long run, we will all be dead, they didn't have any policy.
Yeah. So
right.
I guess right. So if you think about nuisance cases, what Coase is talking about, now there it's not obvious who the injurer, who the victim. I'm the dry cleaner and you're the sheep farmer, or whatever. Who's the injurer and victim? Then I think what you're talking about makes perfect sense there. It's because we don't have there's no different kinds of interests here. It's just two types of land uses that are conflicting. And so how are we going to call one the injurer and one the victim when we don't have any other way of distinction? So I'm completely with you for that class of cases. But if you broke my arm, I'm the victim. I think that's
Depends
what most
how
people
I broke
would
your
say.
arm.
Well, you may not have an obligation, right? Well, if you broke my arm because I was punching you and you withstood it.
I can't resist telling the story of not so shortly after Coase wrote, Jim Tobin, my teacher, didn't buy Coase, and we had a debate moderated by Boris Bittker in which I was presenting the reciprocity position. And Jim said, but surely it's the case that if somebody wants to make noise, the cost is of noise making, and it bothers the scholar who does that. And I took the position, no, it's just as much this person who loves silence and who is imposing that. Now, there you might agree with me, but in the automobile you don't. And we went back and forth, and he got redder and redder and said, it's a noisemaker. And I kept saying, no, it's a silence lover. And finally, Bitker leaned forward and said, Jim, you don't understand. Guido is an Italian. That is, he loves to make noise culturally. And so that what is obvious and what is not itself may depend on a cultural, on things which is why I agree with you.
So the theory of the Italian conspiracy possibly...
That's right.